this briefing this evening. My name is David Edwards, I'm the Director at the Council. I'm here to chair the briefing this evening. We will have a presentation in which I'll introduce you to other people, other officers who are with me. The purpose of this meeting, this briefing this evening, is for briefing members of the Planning Committee and the West Area Planning Committee who are looking at the discharge of the Condition 19 on the East-West Rail Phase 1 scheme. That planning committee is next week. So the purpose of this meeting is for officers to brief members. There's no decision being taken this evening, and therefore it is taking members through and answering their questions in terms of the officer report they've heard. We have also been asked by members to allow the facility, give a facility for those members of the public who are interested to make a statement as well. And we'll go through the agenda in a minute, but there's an opportunity when members have been briefed and have the opportunity to ask officers any questions for members of the public to make a statement at the end. I'm conscious this room echoes. I hope you can hear me at the back. We have microphones, I'm not certain if they're working or not, but please indicate if you cannot hear anything. And we'll try and raise our voices because I know that after about half an hour everybody starts to get a lot quieter. On the basic housekeeping arrangements, all I can tell you is that if there is a fire alarm, it is a fire. So please leave by the nearest exit. I'm sure you're all aware that there are WCs on the ground floor. I don't think there's any more housekeeping that I need to do. So, the first part of this evening is to run through a presentation which seeks to encapsulate all the technical information and the analysis that officers have undertaken in preparing this report. So I'm David Edwards, I'm Executive Director here and will be chairing the briefing this evening. I'm joined by Fiona Bartholomew, who's the Principal Planning Officer, who's been extensively involved with this particular case. Also David Stevens from our environmental health side, who of course has been extensively involved in the noise and vibration issues, and also Mike Morgan from our legal team, who has been advising on the legal aspects of the planning considerations. So the purpose, as I've said this evening, is to outline the background and the context of the committee, set out the technical advice, explain the officer's recommendations, take questions from members on that. I think if I can ask members if they would ask questions at the end of the presentation, I think it would be easier rather than stopping and starting, so we can get through, if you like, the background of this. And then to hear any statements from members of the public who wish to make them. So I hope that's clear and a reasonable running order for getting us through. That's a very long list in terms of the briefing. We will try and keep it moving forward, but there is a lot of information to cover. What I should say, just by way of opening too, is that this is a complex and unusual case. We are not aware of another circumstance where the Secretary of State has effectively delegated to the local planning authority under a Transport Works Act the discharge of conditions for noise and vibration. So it is a very unusual circumstance we all find ourselves in, not altogether comfortable either, I can say that as well. So we have worked with it, we have sought to engage with residents and with Network Rail and all the technical experts, but it's not been straightforward, I think, as everybody understands. So, with that in mind, I'll then ask Fiona to sort of set the background in terms of the information. Thanks.
Thank you, Chairman. So, deemed planning permission was given by the Secretary of State for Transport for East-West Rail Phase 1 in October 2012. And a member of the public asked me earlier, what does deemed mean? And it means that it was deemed to be given, planning permission was given through the Transport and Works Act rather than the Town and Country Planning Act. Condition 19 when the planning permission was given, contains a range of things, but for the purposes of the discharge of this condition, it sets the reasonable planning scenario that is to be used in predicting noise and vibration for the schemes of assessment, and it prescribes the noise and vibration levels which are not to be exceeded. Condition 19 also required independent experts to be appointed to comment on the robustness of the schemes of assessment. As the Chairman has already said, very technical and very complex. The Chairman has also mentioned that this is an unusual situation. So the Council's role is to consider and determine the schemes of assessment. We cannot revisit the Secretary of State's original permission. Now that's in common with all discharge of planning conditions. The Council and the planning committees grant the planning permission with conditions every week, and when we're discharging the conditions, say for landscaping or for vision displays at junctions or whatever, we don't go back and look at the whole principle of the development. We simply say, is the landscaping itself sufficient, are vision displays and so on. So we can't go back and revisit the Secretary of State's decision on East-West Rail Phase 1. In terms of noise and vibration, therefore, we cannot ask the question, generally, is East-West Rail Phase 1 acceptable in noise and vibration terms? We can only ask, because the Secretary of State drafted the condition in this way, we can only ask, will the scheme meet the policy levels in the noise and vibration mitigation policy? And in determining the application, I'm so sorry, there's some disturbance at the back. Because people leave this meeting and anxiety. And in looking at the factors that we can take into account in determining. I'm here. Shh. I'm so sorry. So we can only ask, will the scheme meet the levels set out in the noise and vibration mitigation policy? And we can only take into account the reasonable planning scenario that is set out in the noise and vibration mitigation policy. And so, in summary, concerns about future possible intensification of the use of this line cannot bear on the Council's decision. Yes, you can see that. The assessment that the decision that the Council is being asked to make at the moment only refers to Section H of East-West Rail Phase 1, which starts in the north, just north of Lakeside, and in the south it finishes at around St Edward's Avenue. On that map I've also shown where the original position of switches and crossings was adjacent to Bladen Close, and a revised position around Lakeside, and this will come into consideration later. I can easily scroll back to this slide if we need it, but that's a change in position of the switches and crossings that was negotiated as part of the processing of this application. So the context for the Council's decision, the information that the councillors will have to help them make their decision. There are 3 schemes of assessment which have been submitted for Section H. 1 for noise and 2 for vibration, 1 covering the plain line and 1 dealing with the switches and crossings. And if these are found to be acceptable by the committee, the condition can be partially discharged in relation to Section H. So the context for the committee's decision comprises the deemed planning permission, the strict wording that the Secretary of State laid down, the detailed wording of condition 19, which extends to 2 pages and is reproduced in the committee report, the noise and vibration mitigation policy, which sets out the acceptable levels and the reasonable planning scenario, the wealth of public comment and objections. These are substantial objections that have been thoroughly researched and very comprehensively expressed and are maintained. The changes and clarifications that have been made as a result of negotiations with Network Rail, the reports of the independent experts who all agree now that the submissions are robust, and the advice of ARUP on a vibration only. Again, ARUP agrees the submissions are robust, and ARUP will be brought in to assist with the consideration of vibration. We've included this slide because I won't say that the objections have been withdrawn or anything, but the issue has crystallised down into the fact of the concerns of local people about the impact of freight trains when East West Rail Phase 2, which is Bicester to Bletchley, is implemented, and the implications of High Speed 2. Now, East West Rail Phase 2 has been taken into account. It's the second phase. It's the later phase after Phase 1. It doesn't have planning permission yet, but assumptions about train frequency, train types and speeds were fully considered in the environmental statement and the noise and vibration mitigation policy. And the Secretary of State's decision was based on those assumptions. And those are the assumptions that have been carried forward into the schemes of assessment that the council, that the members, the committee has to consider. HS2 is not referred to in any of the documents. It currently doesn't have planning permission. The possible impacts of freight trains from HS2 are therefore not within the scope of the schemes of assessment that Network Rail have submitted to us, and would not be expected to be taken into account because, as I've said already, the reasonable planning scenario doesn't include them, and that is the only scenario that the council can take into account in assessing these schemes of assessment. It's been a long road. The iterative process that David and myself and Michael have been involved in started before the submissions were made. The permission was given in October 2012. At that time, lead case officers David and myself were identified, and we've been working on this continually. So we have a very broad understanding and a deep understanding of the issues. And we've actually also been discharging other conditions. There are about, I think, I've forgotten the precise number, I think it's 22 conditions applying in Oxford City, and we've been discharging those as well over the last 2 years. We've liaised with Charwell District Council because, of course, we can only deal with the scheme as it is in Oxford City area. We've used expert advice. We've liaised with Chiltern Railways initially on the terms of appointment of the independent experts. And we've developed a communications protocol to ensure that there's transparency in and security, if you like, in all the communications between the applicants, between Charwell, between the experts and ourselves. And Chiltern Railways and Network Rail refined their methodology and approach before they made their final submissions, as a result of technical input from ourselves and our advisors. There's been a huge amount of public consultation. Immediately after the submissions were made, we set up a member briefing, and we were authorised to set up public meetings. We've had effectively an open door on this. There is no public consultation required on the discharge of planning conditions. It's not a legal requirement, but the councillors here wanted a consultation to be carried out. Having carried out that consultation, we have taken the comments received very seriously, and we've subjected to the technical ones to scrutiny by our expert advisors. We've had further public meetings, and the local MP organised a meeting, and we latterly, to help, because more and more people were, I won't use a rail analogy, but I was going to say were coming on board with the process, but we've set up a web page so that we can disseminate information quickly. On noise, Network Rail improved their public consultation proposals as a result of pressure from the council. They held a public meeting and they held full public consultation prior to submission, which they did not do before they submitted the vibration scheme, and that we found very helpful. Network Rail have considered additional properties for inclusion in the scheme. They acknowledged that silent rail could be trialled, and this has led to a proposed condition in the officer's report, and they have agreed to clarify their policy for noise insulation. On vibration, Eric suggested that assumptions about the transfer of vibration from outside to inside buildings should be challenged, and this led to Network Rail's acceptance that there would be an exceedance of the acceptable limits at Labour Close due to the proximity of switches and crossings, and this resulted in the crossings being moved to the north, to the location near Lakeside, as I explained when I showed the map. There's been a correction of some recalculation errors pointed out by residents, and a willingness to consider the use of train monitoring through train tracking devices. There's also been an acceptance by Network Rail that they need to carry out noise and vibration schemes of assessment in section I, which is south of section H. I'll hand over now to David, who will take you through the technical details.
Well, this feels a little bit like the impossible task, really, because there is so much detail, so much technical detail involved, and we have a limited amount of time. So what I've done is to focus on certain key terms, some of which apply to both noise and vibration, and some which apply individually to those two topics. And I'm starting with the noise and vibration mitigation policy itself. We've heard about this quite a few times, and it's a key reference document. And what it essentially does is to set out, as the name suggests, it sets out the intentions, the policies, the standards which need to apply, the standards which have been agreed, and thereby the limits, which apply both to noise and vibration control. It also sets out what should happen if those standards are predicted to be exceeded. In other words, the mitigation that would then apply, and also the monitoring of that mitigation later on. So it essentially looks at the fundamental parts of Condition 19 and applies them in a practical sense, in a more detailed sense. And it is that document which was actually upheld at public inquiry and therefore forms part of the permission and therefore part of how one goes about compliance Condition 19. That's a slight repetition of what Fiona said, but it is quite important to what I'm about to say. And really at the heart of all of this is this idea of assessment. So both for noise and vibration, it's necessary to assess the impact of the proposal, both in terms of how it's different from the current and also what the total effect is when it comes into effect. And that has to be done by a process of prediction. In a nutshell, the assessment process involves taking some baseline measurements, using a number of assumptions and usually a computer-based model to actually feed in the data about what's going to happen in the future, and then to predict what the impact is going to be at the locations where you carried out the baseline measurements. It is a very complex process because there are so many variables to take into account. And the predictions that are made have to be qualified and they have to be checked according to some kind of standards, otherwise they're just guesses. The schemes of assessment then are documents which have to contain an assessment process, but they also have to go further than that and to actually state what the outcomes of that assessment are, and as I said just now, if the outcomes of that assessment is that the standards are going to be likely to be exceeded, then what action is going to be taken? and also the proposals for monitoring of that mitigation if it's proposed. So there is a term which we've heard about, this reasonable planning scenario, and that still stands. That's actually set out in the noise and vibration mitigation policy. But you could say that is what's likely to be the situation. And when trying to deal with the risk situation, the risk that might be slightly wrong, what we've actually done is to go a little bit further than that. And so for each of the values, each of the ranges, each of the predictions that are in the reasonable planning scenario, we have looked at, or we've asked the applicants to look at what's called the reasonable worst case. Now that doesn't mean the theoretical, what could possibly happen if everything completely went wrong. It is a reasonable worst case, but it's looking at not just the typical situation, but actually the upper values, the most extreme values in each case. So that is particularly relevant to calculations and also to the level of robustness that has been sought. So the next 3 points really apply only if the schemes of assessment show that standards are going to be exceeded. And in the case of vibration, the schemes of assessment that have been submitted show that the standards will not be exceeded, and therefore mitigation is not proposed. In the case of noise, it is proposed because the noise scheme of assessment shows that the standards will be exceeded, and therefore one moves on to the next part of the noise and vibration mitigation policy, which says, okay, this is how we do mitigation. Mitigation essentially means reducing the impact. In the noise and vibration mitigation policy, there are a number of ways of mitigating, and there's also a hierarchy of mitigation measures, so that one usually starts at source to try and reduce the amount of noise or vibration that's created in the first place. And then if that's not feasible, if that's not reasonably practical, one moves on to other measures. In the case of noise, that is primarily the use of barriers, and then if it is predicted that having used those barriers, there's still an exceedance for some properties, then one goes to the third option, which is insulation, which is a property-related measure. The term best practical means crops up a number of times in the key documents, and although it's not defined anywhere, it is actually defined in the Control of Pollution Act. And I put that definition up there because when we are considering whether best practice has been followed, we do need to take account of these sorts of principles. So what's the state of research? What is available out there? What would be the cost? And on a cost-benefit basis, is that reasonable? And so on. So in fact, the Control of Pollution Act, although it's got nothing to do with this particular provision, it's relevant, and the same principles would apply. And finally, on this general section, monitoring is a requirement if mitigation is necessary. And so the monitoring applies only to those mitigation measures. It's required at 6 months and 18 months after the commencement of the scheme. And its purpose is really to check, to see that the mitigation measures are doing what the scheme of assessment said they would do. And if they don't do what it said they would do, there's a requirement in the condition to put that right. So, moving on specifically to vibration. Again, I've tried to follow this through in terms of a logical sequence rather than going into lots of detail. But it might be worth just starting by saying, well, where does the vibration come from? And the short answer is vibration comes from the wheels of the train impacting on the track. Now, in an ideal situation, both the wheels of the track would be perfectly smooth, and therefore there would be no vibration. But that's a theoretical impossibility. In practice, all of those surfaces, both the wheels and the rails, are not smooth, totally smooth. So as soon as you get an imperfection, what's called roughness, then there is vibration created causes an up and down movement, which actually results in energy being given out. It has to go somewhere, and it tends to go through the ground, through the track into the ground. And as the notes indicate there, it is more likely to be transmitted in softer ground than in firm ground. This is what happens when you use water as well. So, how is it propagated? Well, it moves from the source where it is created out laterally, and it runs parallel to the surface of the ground. And for that reason, it follows the contours of the ground as well. So if you've got cuttings and embankments, it will follow that topography. Vibration, when we talk about vibration, there's a range, of course. They're generally vibrations at the low frequency, very low pitch. And the lowest pitch, the longest wavelength and the lowest frequency of vibration is the component that generally gives most problems because it travels further, it contains more energy, and it affects more people. I should also say, by the way, that the vibration we're talking about here is field vibration. It's not the sorts of vibration that will cause structural damage. It's the same vibration, but structural damage occurs when vibration reaches much higher levels, that are even orders of magnitude higher than that which you feel. In other words, we can feel vibration at much lower levels, and it bothers us at lower levels than the vibration that would actually cause structural damage. So, coming back to this low frequency vibration, it actually travels the stiffness of the ground at about 10 metres is what really is the critical factor. It is also affected by structures, so that when we talk about field vibration, we're usually talking about people in buildings, and so when vibration travels from the ground through into the building, there is an effect on it then. There's a transmission between the two, and there's a transmission factor that's applied in the calculations. The measurements that we apply have to take account of the fact that vibration events are short-term, sporadic. So a train goes by, and then there's nothing. So what actually happens is the dose of vibration is calculated during the entire daytime period, and another value for the nighttime period. And that's represented by something called the vibration dose value, or VDV. So you'll see VDVs mentioned throughout the reports. And it's the VDVs that have actually been set in the standards. British Standard BS 6472 is this one here. And the title is actually a guide to the evaluation of human exposure to vibration in buildings. So this standard was created for this very sort of purpose. And it sets out some ranges of VDVs which are meant to generate a response. It's based on the likelihood of adverse comment. And the standards that are in the noise and vibration mitigation policy are at the lower end of those ranges. Specifically, they are they're between the lower and the middle of the three VDV ranges. In other words, what the standard calls is the difference between a low probability of adverse comment and adverse comment possible. These are the two phrases that are used. Now, the reason why this is relevant is this is a British standard that applies nationally. So regardless of the scheme, regardless of the situation, one would turn to this British standard and would use that sort of terminology. And so the figures that are involved are 0.4 metres per second, 0.4 and 0.2. Let's not worry about the units unless you want me to. 0.4 and 0.2. 0.2 being lower at night. I'm going to move on to noise. I'm conscious of the time. And noise is rather different. That's why it's been dealt with in a separate report. There are a lot of things that are in common between noise and vibration, but there are also a lot of differences. Noise is generated slightly differently, and it also propagates in a different way. So its cause, there are two main causes of train-related noise. One's from the wheels and track coming into contact, and the other is from the noise of the power unit, or the engines, particularly relevant on diesel engines, of course. And those two different components can be, they take it in turns to be dominant, if you like. But in section H, the majority of noise is generated from the first one. In other words, the impact of wheels and tracks. And having been created, it actually radiates both through the track and through the wheels and then out into the open. So it actually increases with speed. The power units, on the other hand, don't. The noise that comes from them doesn't increase with speed because it's a constant. And what happens next is that sound, as we all know, travels through the air, travels as pressure waves. It is affected by structures. It's much more readily absorbed than vibration is. And again, there is a frequency range, but in terms of measurement, we have to have some kind of average. So we tend to measure in sound pressure, the units of sound pressure, which is decibels. We also tend to use the A-weighted scale, so you see this term dBA being used. And that's because dBA particularly focuses on the human hearing range and the frequencies which are most annoying to people. So this measurement of decibels, it's commonly used, it's not that commonly understood. But again, as with vibration, if you're going to compare one situation with another, or the current with the future, and so on, it's necessary to average out the noise in some way. So the equivalent continuous noise level, or LAQ, is used to actually take a period and to actually say how much sound pressure, noise energy is there in that period, and we'll come up with a figure. We can then compare that period with another period, and that's why LAQ is used. And it's universally used when you're looking at environmental noise impact. In this case of trains, it's also useful to look at what happens when an individual train comes by, because of course that could actually distort your LAQ, and also it could cause quite a lot of impact to people. So there is also, in the schemes of assessment, it's been required that they will take account of the impact or maximum noise level when trains pass by. And there are standards applied in the noise vibration mitigation policy, both for the LEQ and for the LMAX values. It just might help your sort of interpretation if you bear in mind that sound pressure doesn't behave like we perceive noise. It doesn't behave like volume. It doesn't actually behave in noise levels can't be added in an automatic way. That's because there's a logarithmic behaviour that noise and sound pressure uses. Setting that aside, that complexity, as a rule of thumb, 3 decibels is the smallest change which is generally accepted that people can understand or can perceive. So anything less than 3 decibels, you can barely notice that change. And another figure, 10 decibels, is generally used to describe a doubling or a halving of volume. So again, that's talking about how we perceive noise. That's just so that you can sort of get the context. Standards, well, in the case of noise, they're a little bit more well prescribed than in vibration, and the calculation of ground noise, CRN, is a document that's been around for quite a long time, but it's been amended a number of times and it's still standard reference. And what that sets out is a procedure for how one should assess noise and measure it when it comes to rail noise. It's a very specific method, and if it wasn't to be used, then the applicant wouldn't have got it right. It doesn't actually include an LMAX figure, but that has actually been calculated in a way which has been approved by the relevant experts. Now, under noise, I'm just going to mention mitigation monitoring because, of course, as I said earlier, those are relevant to the report. Mitigation, the hierarchy that is set out in the noise and vibration mitigation policy starts with outsourced measures. And in the scheme of assessment, there's a discussion, if you like, of those measures, and they are actually discarded, largely because, if not in all cases, because they're not considered to be reasonably practical. And there are arguments set out as to why those are. In the case of rail dampers, The reason why they can't be used is because they can't be used on this type of high-speed track. They have been used elsewhere on slower and light railway tracks, but Network Rail have said that there is no type approval available for track speeds the same as those in this scheme. However, that doesn't mean it couldn't be done. It just means that type approval would need to be obtained. Nobody knows whether type approval would be obtained if one sought it. So we've had to accept the current situation, which is it's not available. However, we feel that it is worthwhile pursuing that type approval. Nevertheless, coming back to the noise and vibration mitigation policy, as I said earlier, if mitigation at source is shown to be not reasonably practicable, one moves to the next layer, which is the use of noise barriers, and also, if necessary, noise insulation. Now that has been set out, the whole scheme has been set out in the scheme of assessment, and that all forms part of the standards that are in the noise and vibration mitigation policy. So our tests there have been to see whether that scheme has met those standards. And finally, on monitoring, as I said earlier, it's required where mitigation has been adopted at 6 and 18 months. Just a small detail on this one, but because originally there would be monitoring at 6 and 18 months and then another set of monitoring when the second part of the works were put into place, well, of course, that's not the intention now, because the intention is that they would all be put into place in one go, and therefore one set of monitoring has been proposed. As I said earlier, any defects in that mitigation would need to be put right.
So as a result of the work that has been done over the last few months, it has been agreed by the independent expert and Arab, whom the council appointed separately, that the methodology, the data, the assumptions and the calculations used in vibration schemes of assessment are robust. On that basis, the way the permission and the condition are constructed, the detailed wording, means that the council can rely on them and as part of the discharge of the condition. The schemes of assessment in terms of vibration show that taking the reasonable worst case scenario, the vibration levels will be likely to increase, but will not exceed the limits in the policy, and therefore no mitigation is required. Concerns expressed about the possible future use of the line, apart from those forming part of the reasonable planning scenario, fall outside the remit of condition 19. There is therefore no basis for refusal or deferral of the decision on vibration. On noise, the story is similar. The methodology, data, assumptions, and so on are considered by the experts to be robust. The noise schemes of assessment show that taking the reasonable worst case scenario, noise levels will exceed the thresholds, and therefore mitigation is proposed and is comprehensively detailed in the scheme of assessment. And they meet the requirements of the policy. And whilst noise dampers are not currently available, as David has just said, Network Rail have offered a trial to install them on a trial basis, and we've suggested that as a condition. As with vibration, future use of the line, apart from that already accounted for in the policy, cannot be taken into account, and there is no basis for refusal or deferral of the decision. Michael is going to speak to conditions on the conditions discharge.
Good evening. Starting with a fairly basic point, approvals under a condition can be conditional. There is no problem with imposing conditions on determinations such as those currently before the Council. The Secretary of State does, however, impose a number of requirements which all have to be met for any condition which is to be imposed. It has to be necessary. The Secretary of State does not permit conditions to be imposed simply because they do no harm. go beyond that. The council can't, of its own motion, decide that the condition could have been better worded, the policy could have been worded. All of that has been set in place by the Secretary of State, and those guidelines are hard guidelines which the council has to work within. Conditions have to be enforceable, statement of the obvious, no point having them if they're not. They have to be precise, which is really just enforceability under another guise, and they have to be reasonable in all other respects. That covers a multitude of sins, examples being you can't use conditions to require land to be given up, you can't use conditions to require payments to be made, you can't use conditions to effectively take away the benefit of an approval or a permission which is being granted at that time. And as has been said previously, it's not possible to revisit the decisions already made by the Secretary of State. The Council is working strictly within the scope of what's been left to it by the Secretary of State, rather than winding things back and revisiting matters which have already been dealt with. Turning to some condition specifics, which are essentially related to the conditions which officers are recommending and those which they aren't. As can be seen from the report, officers are recommending a condition requiring the alignment of the works to be as submitted in the schemes of assessment on drawings. The reason for that is that the schemes of assessment are all calculated and demonstrated on the basis of a particular alignment. Network Rail has made the point that, as is normal in the Transport Works Act orders, they've got limits of deviation. Under the statutory instrument, they have scope to laterally and vertically move the alignment. If they did that, officers could not be confident that the policy standards for vibration and mitigation would be met. So in that circumstance, there would be an officer recommendation of refusal. That is why this condition is seen as meeting all the tests, obviously specifically necessity. Rail dampening, which David alluded to, this derives from the policy requirement for at-source mitigation where reasonably practicable. It's quite correct that Network Rail has said, and it's factually correct, that the rail dampening solution is not approved. So, as we sit and stand here now, they don't have a power to put it in. Having said that, officers aren't satisfied currently that approval couldn't be obtained in time for rail dampening to be used. As such, officers are recommending in connection with noise, because it's in connection with noise the policy talks about the at-source preference, that a condition be imposed requiring rail dampening, albeit with a proviso that if Network Rail satisfy the council that it's not reasonably practicable, that they don't have to do that. The reason for the proviso is this business about being reasonable in all of the respects and taking away the benefit of the permission. If we didn't have that proviso in and approval wasn't obtainable, we'd have granted permission subject to a condition which takes away the approval. Train numbers. As has already been mentioned, the policy sets out train numbers and goes so far as to say that the noise and vibration mitigation will be based on those train numbers. That is a classic, and frankly rather extreme example of where the Secretary of State has said what the ground rules are. So any attempt by condition to go beyond that policy and that requirement would be going outside the scope of the matters before the council for determination. It wouldn't be fairly and reasonably related to determination before it. It would be directly connected to determination before it. Other noise limits and controls. Again, it's the same issue. The policy sets out the requirements in conjunction with the conditions. winding the clock back, revisiting the Secretary of State's decision, going beyond the condition and going beyond the policy which is built into the condition. The condition requires the assessments to show that the policy standards are met, not some other standards. Similarly, monitoring and potential remedials. As David's mentioned, there is limited monitoring requirements in the policy in respect of particular kinds of works. That is all picked up, so far as it can be picked up, in the policy, and amongst other things, condition 19 requires those policy requirements to be complied with. That's enforceable in its own terms. Again, to try and impose additional requirements would be going beyond the scope of the condition before the council. Similarly, train speeds. On the basis that the experts say that the policy standards are met, any condition addressing train speeds couldn't be necessary and fail the first of the tests. We also appear to have an issue on train speeds relating to the Secretary of State's previous considerations and previous determinations. The actual decision letter by which the Secretary of State decided he was going to make transport and works order specifically stated, it's paragraph 24, so I'm only going to partially quote for it. The Secretary of State notes that some objectors continue to argue that speed limits should be imposed at various locations as a means of reducing the noise and vibration impacts of the scheme in operation. Skipping forward, reference to condition 19, effectiveness in mitigating noise and vibration of the scheme. The Secretary of State is satisfied that imposing speed limits for those purposes would be unnecessary. That appears to be a clear statement on its face in the decision letter determining the transport and works order. That was all I was going to say about condition specifics. Obviously, if any other types of conditions are raised between now and the actual decision being made, then we'll look at those by the Secretary of State's test document.
Thank you very much, Michael. It's worth also just putting in a little bit of wider context to the decision in front of the committee. We've obviously had a lot of engagement with Network Rail, and they've been keen to emphasise to us, and therefore I need to share it with the committee, that this is part of a wider series of improvements, a programme for the area, and of course these are linked in various ways, and two particular issues they are drawn to our attention. The first is the planned closure of the Oxford-Paddington line next year for about 3 weeks in terms of work, and that they would intend that if they can run services from Oxford Station, of course, they would need the works that we're considering here in place. So there is an issue there which they would wish to bring to everybody's attention. Second, there's the issue of ecology and nature, of course the seasonality in terms of dealing with the Woolcott Tunnel, bats and so on. And again, Network Rail are keen to emphasise that delay, and they have their own internal deadlines in programming, means that this decision, which is going to the committee, is now, in their words, extremely pressing. And if they are not able to see a way forward on this, has consequent impacts on their wider programme. The second issue, which is worth bringing to the fore to the committee, is the issue that has been raised by residents and others about HS2 and the potential implications, particularly of ballast trains, working trains associated with the construction of HS2. As has already been said, the scope of our assessment is severely constrained by the Secretary of State and by So HS2 is outside that scope of assessment in terms of what we have heard tonight. There is also two other considerations as well. Firstly, HS2 is not an authorised scheme at the present time, although I think all of us know that it is a government priority and therefore being pushed ahead, but it is not at the moment, if you like, a formal authorised scheme in the technical sense. And the other consideration is the issue of ballast, indeed the direction and use of ballast trains has not been determined yet, and Network Rail have been keen to emphasise to us that it is by no means certain that they would be using this corridor, but clearly they couldn't, or they cannot give us an undertaking that it won't either. So, I just have to put that out in the wider context. We've talked already about vibration monitoring arrangements, what might be appropriate, and so on, and we will continue to press Network Rail on this in terms of wider monitoring and so on, but there are limits in terms of what we can require. Similarly, in terms of speed restrictions and so on, members may well wish us to take up the cause in terms of speed restrictions. We know Network Rail's position to date, and you have heard, if you like, the ability of us within the planning framework, within the discharge of conditions, to make that a condition. So it is something that is not entirely within our gift. Certainly in terms of HS2 and the concerns there, I think members would definitely want to consider, along with residents, making representations in terms of the HS2 process, but it is outside the concerns, or it's outside the considerations we have today, and there may be a discussion further on that. So, we now have to the point that takes us through what is a pretty complex set of analysis and the recommendations. I hope that's been helpful. There is obviously a lot of material in the report that you already have, and it is a complex position. But I think we've tried to crystallise this down now into what are the key issues before the panel, or before, I should say, the committee, in terms of the discharge of conditions and the extent to which the limitations, I think it's fair to say, that the council has placed in terms of what it can consider reasonably in terms of the scope and the assessment, which, as I say, we have the expert evidence now, which does agree and advise the council that the scheme of assessment is made, and that in terms of the conditions that might be set out, where we can go is to ensure that, if you like, the scheme that is being assessed is the scheme that is implemented, and that monitoring, where this is available, is put in place. But beyond that, we have significant limitations on what we can recommend, and indeed what appears to be in the council's gift. So I'm now going to ask to members to raise any questions. It may be helpful to try and group them. There are questions up there which you need pretty good eyes to be able to read them, so perhaps if I read them out, maybe that's helpful. And there may be more questions. These are just ones that came up to us. The first one, it is given the importance of estimates of train numbers. Does the Council and Planning Authority have any power to control what these numbers will be? And that's from Councillor Gans, and I think, Mike, do you want to answer that? But I think we have heard the officer's advice on this.
The very simple answer is no.
Right. Okay. Moving on then, does the Council have the authority to impose speed limits on trains as a planning condition? Right, I've got a sense of a theme here.
On the
one says, is there consensus amongst experts about what the limits should be? For example, some believe that slower trains cause more noise and vibration because they take longer to pass at a given point. Craig, do you want to just comment on that?
Yeah, so I think it depends what you mean by that question, because the consensus has not been reached in this particular assessment, because there was no need to reach that consensus. If it had become an issue, then of course there would have been a need to reach a consensus between the experts. Having said that, there's no disagreement between the experts. The report appendices do contain some advice from our independent expert on noise about how speed affects noise, and there's also some information in the appendix 29 of the vibration report about how speed is affected by vibration. It's a complex answer because, as I was saying in my presentation, it depends which bit of noise and which part of the track. So there is no disagreement amongst the experts, but there has not been a consensus for those reasons.
Thank you. And just to be clear, I mean, the advice from the experts is that the speed of assessment is within the thresholds that have been set both for noise and vibration after allowing for mitigation. That's correct. So the fourth question we've got here is, if monitoring of noise and vibration is required as a condition, who would carry it out and decide where it is done? What powers would be available to the council if the results differ from those predicted?
Well, I covered that from the point of view of actual monitoring that will be required on the basis of the noise assessment. It's a slightly academic question if it was about conditions, because as we've heard, we can't impose further conditions. There's no justification for that. That would be the office of view. So the monitoring measurement, when it does take place, and I'm referring now to the monitoring that is part of the actual approved scheme, or rather the submitted scheme, that does have still to be approved by us. So there's another part of the condition which requires the monitoring schemes to be approved and also the outcomes to be looked at. So we do, although the monitoring is carried out by the applicant's agents, we still get a chance to look at it, take issue with it if necessary, and also to see what corrections are carried out if there are any problems that have been identified with the mitigation that has been put in place.
Thank you. Other questions from members? So shall we start? Susanna, I can see.
Thank you, yes. Thanks very much for the briefing. It was helpful, though I don't think there's still loads of questions and concerns. I have several questions, but I'll make them very brief. Is Section I being dealt with in exactly the same way as Section H? That's one question. And then, how effective are noise barriers generally felt to be, please? And then on the question of the speed of trains, that was very interesting. Although we can't impose a speed restriction, I think we should press very hard to have a voluntary speed restriction from Network Rail, especially at night. If you could tell them that if they want any goodwill from people of Oxford, they should use a voluntary speed restriction, especially if we're not happy with the other mitigation measures, of course. And then finally, I know there's some concern among some residents about the so-called independent assessors that the City Council used. I just wonder if you could comment, please, on how independent you feel they truly are.
Let me take the last one first. I mean, the independent assessors, we have had two. The original one, Chris Jones, vibration. We've also had our own assessor, Arabs. All of these people work in the rail industry, but they also have professional reputations. I mean, it's not an uncommon position for it to be a limited pool of experts operating in specialist fields. I think we certainly feel, from our point of view, in the council in appointing Arab, we've put in a check and challenge, which has been helpful, I believe, in terms of ensuring that there's been robust assessments. in some areas. So I think we can fairly say we are as satisfied as we can be. It is inevitable that people will say, well, the consultants work for Railtrack or they work for somebody else in the industry, therefore they are compromised. You're never going to be able to prove that absolutely. I can honestly say that the consultancies that work in there, if they were not professional and if they were found not to be independent, then their reputations and their ability to operate in those areas going forward would be severely compromised.
Are they chartered?
Chartered in what sense?
Are they chartered members of their bodies?
Yes, they are. They're all professionally qualified, and their CVs, with respect, as long as there are. It is a specialist business. Sorry, can I move on to the other point?
Yeah, section I and section H, yes. Section I will be, is the same process because the condition sets down what process you go through. The one big lesson we learned was that we were going to require Network to carry out public consultation before they made their submission. They didn't do that on vibration, and that caused us, I think, a lot more work than was necessary. They did do it on noise, and that helped us get to the key issues quicker.
And noise barriers, yes, they're effective. They're not a panacea. They are a standard method of noise mitigation, particularly when it comes to transport noise. And a lot is known about how they behave. They often need to be designed and built and put in properly. And the condition 19 actually allows for us to actually be enforcing that stage as well. So that the design and appearance of the barriers would, if we were to approve and give partial discharge, we would then have another successive iteration looking at the details of the barriers. A lot of the details of those barriers have already been set out. So, for example, they have reflecting surfaces to reduce the amount of reflection and so on. So we believe that the specifications that have been submitted with the schemes of assessment are actually correct, and that the noise barriers would perform according to the calculation of rail noise and the standards that would apply.
In terms of speed restriction, just let me finish on that last one. I mean, as you know, the council has already publicly said it wishes to see speed restriction. We can continue to press and campaign for that, but we also have to be straightforward in terms of saying what the limits are for requiring that as a planning condition. So I think that is the position where we are. Sorry. Just move the microphone around.
Thanks, David. Can I say that's been a very clear presentation. It certainly helped me to get my head around these complex issues. And I submitted these questions obviously before this briefing, and you did indeed deal with some of them as we went through. It's very good to ask a question of a lawyer. You can get a straight answer. And the answer to number one was no. However, we as a committee cannot decide how many trains use the line or how fast they go. But we can decide if we think that the applicant has satisfied the condition about how much noise and how much vibration there will be. However, the numbers of trains and their speed affects the cumulative build-up of noise and vibration. More trains means more noise, especially in the context of the variable vibration dose of that rumble, you know what I'm talking about. So if we don't know and don't have any control over the numbers, how do we know how much vibration there's going to be?
Well, Mike will give you the legal answer, but the fact is that these parameters have been set for us. Those assessments were made in the original Secretary of State's decision. So they've already taken a view, if you like, as to the anticipated train movements, and given those to us, if you like, as part of the basis of the scheme of assessment. What we've also said is we can't take into account things like potentially HST and others because they were not part of the scheme of assessment and and therefore not include. Mike, is there anything you want to add in terms of? So I mean, I think that tells you, if you like, the Secretary of State has already decided what the criteria are and the basis of assessment, has then handed it to us, for us, if you like, to check as to whether, on that basis, and with the professional advice we've got, is the condition discharged. And that is where we are. We've been given very limited hand.
Thank you, David. A lot of what we've heard tonight, most of what we've heard tonight is theoretical. The trouble with that approach is that the local community's experience up to about a year ago, the main train services stopped, the community's experience is that whatever anybody predicts about the geology, whatever anybody predicts about the topography, that in fact the trains that were running on that track caused nuisance, particularly and especially the freight trains, and particularly the stone trains. So whilst I don't want to talk about HS2, in fact the thought that there could be a lot more stone trains in connection with HS2 naturally has got the community alarmed. Can I take the points that are on the board because they hang together? I thought I heard Michael say that the consent, if it is given by the committee in a week's time, would in fact be on the basis of the numbers of trains, both freight and passenger, and it's 8 and it's 8, isn't it? 8 per day and 8 per hour at peak time. That in fact, that was the basis on which an approval will be given. Now the implication of that is that any numbers that are greater than that will have to be the subject of a further application. Did I mishear it? Am I misunderstanding? I hope I didn't, and I hope it's not. Item 3, what the limit should be, well that surely is pretty clear. It's in the Minister's approval, and it is in fact the British standards. The British standards are the standards that we're working with, or they're not. And the argument about a fast train going through quicker, we're talking about peak noise levels. That's what people find objectionable. Who would carry it out? Well, I would suggest that the Network Rail must carry out the monitoring of noise and vibration. It's their job, and the results of that monitoring should go to the independent expert continue to be employed by the city so that he can see whether or not they are exceeding the acceptable limits that are laid down in the British standard. Well, and come back to 2 now, speed limits. Well, the ministers, if you read the minister's paper, said that speed limits were not necessary because she believed that the other measures suggested were sufficient to control the nuisance caused by noise and vibration. So therefore speed limits were not necessary because other measures were going to be satisfactory. But those other measures include monitoring. And why is it considered by the officers sensible to monitor only where problems are predicted? Surely we need monitoring, I say all along the line. I don't mean all along the line, I mean in selected places along the line, not just where the predictions say that there are going to be problems, but in other places too. Because unless you monitor what is going on, and you do it comprehensively, and you do it in 6 months, and you do it in 18 months, I would like to see it in 5 years as well, but that's pushing it a bit too much perhaps. But unless you monitor it thoroughly and properly, you're never going to know whether or not it meets the standards that are laid down by the Minister and laid down by the British standard, and we may be subject in a few years' time to far more nuisance than in fact was given permission for, unless it's monitored.
Thanks, Mike. Do you want to just pick up on the director of the conditions here?
Okay, certainly. Yes, I did say that the assessment has to be on the basis of the movement assumptions in the policy. That's because that's what the policy says, and because the condition says that the assessment for the council is on that basis. That's the whole premise of the noise mitigation policy, and the policy says that explicitly. It does not follow that the council can then put a condition on limiting movements to that figure. Indeed, exactly the opposite would be the case. If that was what the Secretary of State was doing, the Secretary of State would have imposed a condition on the deemed planning commission limiting movements, and then he wouldn't have had to provide us with assumptions for the scheme's assessment because we'd have been dealing purely with what the deemed planning commission said could be done. So I'm afraid that argument doesn't hold water at all. In terms of the monitoring you've referred to, again, the monitoring is required by the condition in accordance with the policy. The policy reference is 2.11, and I can only repeat my previous comments that the Secretary of State has dealt with that. The Council does not have scope to go back on that. Similarly, your comments about speed limits and the Secretary of State's reasoning. The Secretary of State has come to a decision on that. If the Secretary of State's reasoning was wrong, well, that may well be the case, but that is what the Secretary of State's conclusion was. We don't have the power to say that he was wrong and go back on it and act on the basis of what the Secretary of State should have done.
Does that conclude members' questions? Sorry, one front.
So can I just clarify that at the moment we're going to have monitoring at 6 months and 18 months? And is that going to be of noise and hopefully, certainly noise and hopefully vibration too?
No.
But not necessarily vibration. I'm just going to ask them to.
There's no proposal to monitor vibration because there's no mitigation proposed, and therefore the noise and vibration mitigation policy doesn't require monitoring because it only requires monitoring of mitigation.
Right, because what if there is wrong? It just would make it much easier if we can monitor the vibration. If their experts are right, well that's fine, and they don't really need to mitigate it. But if their experts turned out to be wrong and it did need mitigating, we would then know.
We can ask for it, but we can't require it.
Okay, that's frustrating.
Yes.
Could we, and also we just wondering, is it set in stone, does it have to be 6 months and 18 months? Is it set in stone that it's going to be 6 months and 18 months? Or could we put it out longer? We might mention 5 years. I'm just thinking that might be one way of protecting our residents against future use.
Right. Well, there's a little bit more to it than the fact that it's 6 months and 18 months. The answer is the noise and vibration mitigation policy does specify 6 months and 18 months. The reason for that is that at 6 months they should be able to measure the effects. But it's possible that they would need to make some adjustments. Possibly, if we were at the public meeting in December, they said that we might even find that some extra properties needed to be brought in. So they would then mitigate them, and they'd be able to test that again at 18 months. But you're quite right that neither of those measurement exercises looks to the future beyond. So in the noise scheme of assessment, they explain that they will predict, on the basis of the measurements, what will happen in the future. In other words, they revisit the modelling process that's already been carried out, but they qualify it by the measurements that they will take of actually mitigated properties. And then that's the best, it's not a guess, the best prediction that could be made about what's going to happen in the future. And as we know from the early part of the presentation, that would include the predicted train movements which are related to East-West Rail Part 2. But they're predicted because nobody has the crystal ball to say what they're actually going to be. They go back to what was said in the environmental statement and what was then taken into the noise and vibration mitigation policy. Is that it?
That brings us, I think, to the end of members' questioning. Members asked us to say that members of the public wish to make a statement here, that we will create that opportunity. What I have here, what we asked people to do, was to write down on a list if they wish to speak. And I have 1, 2, 3, 4, 5 names here. And one or two people have either written first or not first or second. So I propose to take that off the list, if you like, and to work our way through. We obviously haven't got the luxury of very extended periods, and what we've said could restrict themselves to 3 minutes as a statement. If we can keep roughly to that, then that gives the opportunity for everybody on the list to speak, and I hope that's fair. There is also a second opportunity in the normal course of business at the planning committee, but I would urge you to arrange that with the planning officers and make sure that if you wish to, that can be taken account of. So I'm looking at my administrative colleagues here. So the first person listed here is David Burrows. If we could stick to the 3 minutes, I think that would try to.
Thank you. My name is David Grills and I'm speaking on behalf of residents in Section 8H. I should say straight away that we're in favour of improving Oxford's railway infrastructure. We welcome the increased capacity, but we've got some very serious concerns which link up with points that have already been made. Our greatest concern is the future certainty of heavy freight traffic running at speeds of 60 plus miles an hour through a densely populated residential area of Oxford. We're particularly concerned about so-called stone trains consisting of very heavy wagons. Calculations by our Professor Buckley show that if just one of the nighttime freight paths specified in the noise and vibration mitigation policy is used by a train of this type travelling in the down direction at 60 miles an hour, as predicted in the vibration scheme of assessment, and incidentally as thought reasonably likely by Arrow, the vibration level will exceed the condition 19 limit at the most vulnerable properties in Wolvercote by over 20%. Could this actually happen? Well, Network Rail has stated in writing that there will be no stone trains travelling above 20 miles an hour and none at night, and that this is the reasonable planning scenario which gives compliance with condition 19. I must say that we regard this as implausible, in fact incredible. It's stated in the policy that the use of freight paths will reflect national freight demand, and from supporting documents that we've read, it's very clear that any increase in stone trains would be a commercial decision by the operators and governed by market forces. This is the reality rather than the technicality. Many people here will know that from October 2013 to June 2014, thousands of tons of fly ash from the recently closed Didcot power station were transported night and day through Oxford, causing great misery to people along the line. At a public meeting last December, Network Rail's project director confirmed that there is nothing to stop, he said, Network Rail signing another fly ash contract. What's more, over the past 3 months, stone trains have actually been recorded travelling at 28 miles per hour and 35 miles per hour in the early hours of the morning. So why should we believe Network Rail's assertion that in future, with a dual-track railway, there will be no stone trains ever travelling at 20 miles per hour? It's simply incredible. Now, of course, I understand that the answer to this is that all of this has already been anticipated in the reasonable planning scenario in the NVMP and the environmental statement. Turn to the NVMP and you find that there are 8 available freight cars each way at night, and it's said that about half of these are likely to be used, and that is the reasonable planning scenario. But in fact, recent East-West Rail presentations have indicated that the consortium has every intention of running the line to the full capacity. Network Rail's latest estimates about the frequency of conventional freight trains and the frequency and speed of stone trains are completely implausible. And all of this is the case leaving aside HS2, which I'll just touch on very quickly. It's come to light that HS2 Phase 1 will be constructed and maintained from a central depot located at Calvert, and that freight trains servicing this depot will use the East-West Rail line. We know from published information that the intention is to accommodate the maximum number of these trains servicing HS2 each night, plus 50%, and the trains will be up to 750 metres in length. Professor Buckley has calculated for us that a reasonable worst-case scenario with all the HS2 trains at night, the vibration limit could be exceeded by as much as 100% at some properties in Wolvercote. Now, I understand that council officers say we must exclude this from consideration. We actually cannot see anything in the wording of the TWA order or Condition 19 or the NVMP to support that contention, and we've actually looked at the legal advice as well, and we don't think it's definite in that either. But I want to emphasise that our objection doesn't depend upon hypothesis about HS2. To conclude, the question facing members of the committee is whether to sign off Condition 19. As David Edwards rightly said, it's a complex and unusual case here. The granting of the condition is rare, it's perhaps unique, so it's a very heavy responsibility. We strongly urge that it should not be signed off unless the following conditions are met. A 30-mile-per-hour speed restriction for freight in residential areas, which is what the inspector assumed at the time of the inspection when he said there wasn't a need for anything. Vibration-reducing track form, effective noise barriers, full post-construction noise and vibration monitoring, and revegetation along the route. They have been supported in a petition that we've got 700 signatures to in 3 days. I hope that councillors will take seriously the views of those 700 people. Thank you.
Right, next I have on the list Keith Dancy. I really would appreciate if people can stick reasonably to the limits, please, because everybody needs to have a contingency. Thank you.
Hello, my name's Keith Dancy. I was born in Oxford. I went to Cheney School. I read engineering and mathematics at Brunel University. And in the second half of my career, I worked for NASA and the European Space Agency. Now, the big problem I have with this is that all the vibration dose values are based on measurements taken at Port Meadow, contrary to the instructions specified by the Inspector at the Public Inquiry and contrary to the advice of the British Standard. The vibrations should have been measured as close to people's properties as possible, not as far away as possible. We have asked Network Rail repeatedly to measure vibrations in our properties and under Wolvercote, and they have refused. They are scared of finding out the true value of the vibrations that we experience. Now, when it comes to vibration propagation, David Stevens only touched on surface waves, but there is more to vibration propagation than surface waves, because propagation goes through the ground and you get subsurface waves as well. And these are particularly important where the vibration emanates from underneath people's foundations, such as in deep cuttings and entrances to tunnels. There are no surface waves when you're looking at the vibration propagation from Crossrail going through tunnels in London. And there, the environmental health officers of the London boroughs fought really hard for their residents to protect them from excessive vibration. We're not talking about surface waves when the train is entering the tunnel in Wolvercote. We are talking about vibration waves which are passing through the subsoil and coming up from underneath the foundations of the properties there. And in that situation, we find that there is a concentration of structural damage, both to residence homes and also to council property in that area. That has never been accounted for in any of these schemes of assessments, and even though residents in that area have asked the officers to request Network Rail to assess their properties for vibration, the council officers have declined to do that. They have only assessed the vibration estimates for properties which are almost at grade on the same level ground as the railway track, not from properties that are above it. Now, these estimated vibration values, which Atkins have produced, have never been tested and they have never been validated. They refuse to validate those values. These are just theoretical values. While our buildings shake and crack, they just rely on estimates. And now, with no monitoring, you are telling us that you're not going to see what the real values of those vibrations are when we have a 6-fold increase in rail traffic, a doubling in the rail speed, with the potential for heavy stone trains travelling at 60 miles an hour. It's a disgrace.
Next on the list I have Paul Buckley.
I'll be brief. I just want to go back to the stone trains again briefly, because people may be confused, because the presentations on the one hand said that the conditions had been met, and the independent experts agreed they'd been met. On the other hand, David has just referred to the possibility that they might not have been met, and it's all down to the numbers of these trains. And we were told that the numbers of trains have been specified by the Secretary of State. The missing piece of the jigsaw is that the Secretary of State did not specify the mix of trains. So with freight, there are some freight trains that make relatively little vibration, and there are others that make an enormous degree of vibration. That's the point. In the calculations used in the schemes of assessment, we only have the word of network rail, that there won't be the very vibration-prone, heavy stone trains at night. That's the problem. But there's another problem. The actual compliance with the condition 19 that's been referred to, and is correct, if you use the numbers in the schemes of assessment, you do predict that the thresholds will be met, but by a tiny margin. At night, the predictions, and it's in the network rounds predictions as well as my predictions, the condition will only just be met. And there's a third point, that the peculiar VDV measure of vibration that was referred to earlier, but we didn't go into the maths of it, it has some peculiar properties. It emphasises, more than might be intuitively obvious, the worst case. Putting these things together means that the small extent of compliance with the threshold, a tiny amount of additional adverse vibration-causing train, if you like, shifts the VDV above the threshold extremely quickly. So, to take an example, the stone trains that we, in Walther Lakeside, have been going past our houses at night for months now because of the construction that's been going on, and some of them go quite fast. They routinely, every night, if they'd been running under the new scheme, would have caused the threshold to be exceeded. That's the problem. And I think people need to be aware of this very serious danger that is kind of hidden by the fact that the schemes of assessment have said it's okay.
Jane Alexander is next on the list.
She's gone.
She's gone, right? Okay. Caroline Robertson is the last I have on the list. Do you want this handed out?
Yes, please. Committee members, it might make sense what I'm about to say.
Okay.
There aren't enough for everybody.
Excuse me, Sharon. I did actually put myself on the list. My name is John Keys. Am I not on that piece of paper?
Well, it doesn't look like it to me, but I'm sure we can fit you in at the end if that's all right.
Thank you.
Fine, Mr. President.
Right, this diagram is what I think represents how residents felt would happen after the inquiry. There was the TWA order to which the Secretary of State for Transport put in the planning conditions. Under planning condition 19, the inspector had written that the reason for this was to ensure that operational noise and vibration are adequately mitigated at residential and other noise sensitive premises. In condition 19.2, he wrote, operational noise and vibration, monitoring and mitigation shall be carried out in accordance with the noise and vibration mitigation policy, January 2011. In the event of any conflict between the two, this condition should prevail. So that means if the operational noise and vibration cannot be adequately mitigated, then that term is dominant over what it says in the noise and vibration mitigation policy. So now we move on to the noise and vibration mitigation policy. And at 1.4, it says it's based on commitments made in the environmental statement. And you can see that I've just inserted here at 1.2, but it says Children Railways passenger services can start, actually it should say no, I'm sorry about that, no later than May 2013, which to me indicates that the noise and vibration mitigation policy is slightly out of date, and we should treat it in that regard. Anyway, moving on. As the Council has correctly said, there are planning assumptions in these, but these don't give either the speed or the times for the trains. And for that, I would have assumed you would go back to the environmental statement, which of course didn't say that stone trains would run only at 20 miles an hour, and that they would never run between 11 p.m. and 7 o'clock in the morning. So that's a variation that Network Rail have put in. Then you base the predictions for noise and vibration on the planning assumptions, and then you look at the noise and vibration limits, and you propose mitigation. All sounds fairly okay. Then we get on to the post-operational monitoring, and I have to read this out. It's actually written above at 2.11. The same procedure for post-construction monitoring surveys and the remedy of defects of performance will be undertaken after the Phase 2B works, that's East-West Rail, have been completed, which we now know have been done at the same time, and East-West Rail services introduced. To me, this last bit is very important because Network Rail are trying to vary what was agreed at the inquiry, what was agreed with the inspector, and what the Secretary of State for Transport signed off on. There is nothing anywhere before the inquiry that said that the mitigation for the East-West Rail services would be based on predictions. And not only that they're going to base them on predictions taken from measurements earlier, but they're going to base these predictions on their planning assumptions. Now, I think these two things conflict, and you cannot see that planning condition will ever be met, which is the operational noise and vibration, if you allow these two things to exist. You either say, okay, Network Rail, it's up to you, you make the planning assumptions, you put in the mitigation, but we will monitor them 6 months after the East-West Rail services begin, and then again at 18 months, which, as Councillor Gotch said, he'd like it after 5 years. That would actually probably bring it up to 4.5 years after the scheme becomes operational, because East-West Rail services won't start until 2019. Then we would see whether or not the planning assumptions are realistic. If they're not, this provision allows the mitigation to be remedied. And I think it would be unreasonable of the Council to sign off on this without keeping in this one protection that residents have for mitigation to be rectified if the planning assumptions are not reasonable and robust. So I would please request that you stick to the terms of the policy and you keep in that second round monitoring after East-West Rail services are introduced.
Thank you very much.
working on a boat in Woodbridge Moorings since 2004, just to the north of Jericho, right beside the main line railway which crosses over the Castle Stream. Together with our neighbours in William Lucy Way and hundreds of other residents living near railway lines between here and Woodcote, we're exceedingly concerned about noise and vibration impacts as a result of substantial enhancement, as the EWR call it, of the track. We are fortunate insofar as we have a legal agreement that says we are to be provided with some noise mitigation, and Network Rail have confirmed that they will honour this agreement. This agreement was reached on the understanding that I would withdraw my objection to the railway planning application. I'm not here to object to this planning application, but to see that the attached conditions, in particular condition 19, are fully adhered to. Now, my reading of all the papers, nothing like as much of an expert as Keith here, or Caroline, or many of the others. But my reading of it is that condition 19 should be ongoing and should not be just handed back to Network Rail. I don't want to sort of get personal about Network Rail, but we have got absolutely no grounds for taking their word for anything. And we have a recent and very brutal experience of the difference between their word and what actually happens. Insofar as we noticed some time ago that they were cutting down trees, a piece of unregistered land, which is the only protection that William Lucy Way has got from railway noise, and it provided us with a lot of screening as well, so wildlife. And we dug into what they were doing, and they said, oh well, we're going to put some sidings in here. So he said, do you own the land? And I said, yes, here's a letter saying we own the land. But that's not proof. And from that day to this, and in fact I asked them several years ago, they have not been able to prove they own this piece of land. So they came to an agreement with us where they would do replanting and reinstatement. They put up a 4-metre high acoustic barrier, and they make sure the replanting was done according to a planting scheme which they did provide us with. It all seemed hunky-dory, and then they just clear-felled most of the woodland. And then the person responsible became unavailable. And I've been following them around for the last couple of years, and this tends to happen. They get promoted sideways, disappear, get sacked or retire when you chase after them. I now regard the city council as our only thin line of defence, so I cannot understand why they would sign off on a condition which I believe the inspector intended was for the ongoing protection of residents. So I would like to ask the question of the panel. You have, Oxford City Council, been conferred with very government-sized responsibilities in terms of monitoring, assessment and enforcement, and this is quite unique, as you pointed out. However, how much clout and resources, indeed funding, has government given you to undertake this very difficult task? And obviously, you probably don't want to answer that now, if you wish. Looking at all the paperwork, the scheme of assessment is a bit of a black box. In fairness to Network Rail, I mean, we are losing something like 35 billion a year. One would want to see all this investment of public money. And by the way, they were nationalised in all but name last August. Go to good use, in other words, to make maximum use of the line, which means also mitigation max to go with it. So rather than arguing about how many kind of big unicorns you can bounce on the end of a pinhead, which is what a lot of this guesswork is about, with all due respect to the experts you've hired and the experts who sort of argued against it, why don't we just say that the noise and vibration policy state stands has been adopted by Chiltern Railways to ensure that mitigation of noise and vibration from trains using railways authorised by Chiltern Railways is provided on a fair basis for all occupiers and landowners along the route to Bristol and Oxford. So we've got this black box, which is we don't know quite how much vibration and noise is going to come out of this. We don't have, we want to use the line to the max. And these levels are not to be exceeded in terms of noise and vibration. So we've got input, we've got output.
Thank you very much.
We do it with mitigation, and don't sign up on condition 19.
Thank you. We did say, no question, since you asked how much the government has given us, the answer is very easy, nothing. Very good. That brings us to the end of the briefing. Thank you very much. Thank you everybody for trying to keep the time, and I hope that's been helpful. Thanks very much.
very much indeed.